Thank you for visiting the Combs Waterkotte website and our Manslaughter Defense Lawyer in Missouri website page. Regardless of the crime, we believe everyone is entitled to the best possible legal defense in the state of Missouri. We have created this audio version of our website page to help you better understand our services and protect your future, freedom, and reputation. If you have been charged with voluntary manslaughter in the state of Missouri, we can help. Don't face the state and court system alone during your voluntary manslaughter charge. Contact one of our Missouri Voluntary Manslaughter Defense Lawyers today at 314-900. Help to protect your rights and future. Combs Waterkotte is committed to handling all voluntary manslaughter defense cases with confidential care and understanding. We are not here to judge you. We believe that everyone in Missouri, regardless of the crime they have been charged with, deserves an aggressive legal defense and to have their legal rights protected. With that being said, let's discuss hiring our voluntary manslaughter defense lawyers in Missouri and setting up a free consultation with our attorneys. Voluntary Manslaughter Defense Lawyer in Missouri. Manslaughter charges are less severe than murder charges, but only barely so. A conviction can still land you in prison for over a decade. The attorneys at Combs Waterkotte have extensive experience defending clients accused of homicide. This serious crime deserves the kind of rigorous defense we provide our clients. What is voluntary manslaughter in Missouri? Missouri law has always separated homicide charges into levels based on the accused's blameworthiness. Premeditated murders carry heavier punishments than homicides that occur in the heat of passion without prior planning. On the other hand, homicide is a serious thing. The police and prosecutors feel pressured to make an arrest and prosecute the accused aggressively to show the public and the victim's family that they're putting forth the effort the case deserves. As a result, the authorities must carefully determine the appropriate charges based on all available evidence, including exculpatory or mitigating facts. Voluntary manslaughter lies in this middle ground. By filing these charges, prosecutors assert that the defendant knowingly killed the victim, but some fact prevents them from bringing murder charges. Because they sit somewhere between murder and involuntary manslaughter, voluntary manslaughter charges can be daunting, particularly if you don't have an alibi or justification for the incident. However, manslaughter charges represent a significant improvement if you plead down from murder charges. Your future is on the line. Call Combs Waterkotte Street. Lewis Voluntary Manslaughter Lawyers at 314-900. Help for an immediate consultation. Manslaughter and related offenses in Missouri. The Missouri revised statutes include 5 homicide charges in the chapter on offenses against the person. 2 of these, first and second-degree murder, apply when the accused intentionally or knowingly causes a person's death. The remaining 3 charges include voluntary manslaughter, first-degree involuntary manslaughter, and second-degree involuntary manslaughter. These offenses apply when someone causes a death, with some attendant circumstances that make them less culpable. Understanding these offenses will help you navigate your voluntary manslaughter charges. Second-degree murder is specifically mentioned in the voluntary manslaughter statute, while involuntary manslaughter might represent a viable reduction in charges for a plea deal from voluntary manslaughter charges. Second-degree murder. Before addressing voluntary manslaughter, you must first understand second-degree murder. Prosecutors must prove that one of the following scenarios occurred to secure a conviction for this offense. The accused knowingly caused the death of another person. The accused intended to cause a serious physical injury, and the victim died. Someone died when the accused committed or attempted to commit a felony. Knowingly means the accused understood the nature of their actions and was aware that those actions were practically certain to cause death. Thus, The first two types of second-degree murder require the specific intent to seriously injure or kill. The third type of second-degree murder is called felony murder. It applies when the accused commits any felony, including nonviolent crimes, and someone dies during the commission of the offense or the subsequent flight from the crime scene. The classic example of felony murder occurs when a teller has a heart attack and dies during a bank robbery. Voluntary manslaughter. Voluntary manslaughter can happen in two situations. The first is when the accused causes the death of another person, under circumstances that qualify as second-degree murder. However, they acted under the influence of sudden passion that arose from an adequate cause. Using the definition of second-degree murder, this means that prosecutors can pursue this type of voluntary manslaughter in two situations. The accused knowingly caused a death under the influence of sudden passion. The accused intended to cause serious physical injury due to sudden passion. Thus, the difference between voluntary manslaughter and second-degree murder often hinges on the definition of sudden passion. Under Missouri law, someone acts under sudden passion when their actions are directly caused by a provocation by the victim or someone acting with the victim. The provocation must occur at the time of the act that caused the death. It can't arise solely from a prior interaction. However, evidence of a prior provocation may be relevant to show why the accused reacted violently to the act that led to the death. For example, imagine that someone comes home early to find their spouse in bed with another person. The law considers the accused to be less culpable because almost anyone could be provoked into violence while acting in the heat of passion. Second, voluntary manslaughter occurs when the accused knowingly assists someone in committing suicide. This offense is self-explanatory, although the statute doesn't define what level of assistance makes someone culpable for suicide. Involuntary manslaughter. Involuntary manslaughter falls below voluntary manslaughter on the scale of homicide charges. First-degree involuntary manslaughter occurs when someone recklessly causes a death. Second-degree involuntary manslaughter applies to deaths caused by criminal negligence. Both of these offenses involve unintentional deaths. The difference between recklessness and criminal negligence is the degree of carelessness. Recklessness requires conscious disregard of a substantial and unjustifiable risk of death, while conscious disregard means the accused was aware of the risk but willfully ignored it. Criminal negligence only requires a gross deviation from the standard of care. As such, the accused doesn't need to know or understand the risks involved. All that matters is that they acted with such carelessness that they fell far short of the caution required for the situation. For example, someone might commit second-degree involuntary manslaughter when they take allergy medication and cause a fatal crash despite the warnings on the box. Defenses against voluntary manslaughter charges in Missouri. Devising a criminal defense strategy in voluntary manslaughter cases requires great care. Some justifications, such as self-defense, may require the accused to implicitly admit that they caused the victim's death. With this in mind, it's recommended that you consult an experienced attorney to understand the trade-offs and potential benefits involved with each of the following defenses to voluntary manslaughter. Alibi. An alibi is a claim that you couldn't have committed the offense. Typically, an alibi includes evidence showing you weren't present at the crime scene when the offense occurred. However, you might also have alibi evidence showing you were present, but physically incapable of causing the fatal injury. For example, you might not be tall enough to have struck the victim in the head, as alleged. Mistaken identity. Mistaken identity is similar to an alibi. It usually happens when the police have multiple suspects and incorrectly conclude that the accused committed the homicide. This might occur during a riot or bar fight when several people might have caused a victim's death. We can often use witness testimony, video recordings, or other evidence to fight the charges in cases where mistaken identity is a factor. No intent. You must have knowingly caused the victim's death or intended to cause serious physical injury. If the prosecution can't prove your knowledge or intent, they can't secure a conviction. We can also introduce evidence offering an alternate explanation that shows you lacked intent. For example, suppose that the prosecution alleges you deliberately gave someone an overdose of fentanyl. We can defend you by showing you thought the substance was methamphetamine and wouldn't cause an overdose. You might escape liability for voluntary manslaughter, but you could still be liable for involuntary manslaughter. Self-defense. You're entitled to use deadly force to defend yourself in certain situations. Specifically, you must satisfy one of the following conditions. You reasonably believe force is needed to protect yourself or defend others from death, serious physical injury, or a forcible felony. The victim unlawfully enters or attempts to enter your home or vehicle. The victim unlawfully enters or attempts to enter a property you own or lease. If we can prove self-defense, you may receive a dismissal or acquittal. Potential sentences for voluntary manslaughter in Missouri. Voluntary manslaughter is a Class B felony in Missouri. The penalties for this type of offense can include any of the following: punishment, imprisonment, fine, sentence enhancement, eligibility for conditional release. Sentence: at least 5 and up to 15 years in prison. No fine. Upgrade to a Class A felony if you have 2 or more prior felony convictions. You must serve at least 2/3 of your sentence if it's 9 years or less. You can be released 3 years early if your sentence is between 9 and 15 years. Why choose Combs Waterkotte to defend you against manslaughter charges in Missouri? Our attorneys take homicide charges seriously. We know the stakes you're facing and will work diligently to secure a dismissal, reduction, or acquittal. You deserve a fair process. We'll thoroughly investigate the actions taken by the police and prosecutors to ensure that they've respected your rights. Our attorneys have handled over 10,000 criminal cases, including many involving homicide charges. Contact us to discuss your Missouri voluntary manslaughter charges. A voluntary manslaughter conviction can result in a lengthy prison sentence and a felony criminal record that will follow you for the rest of your life. Contact Combs Waterkotte online or at 314-900. Help to discuss your charges and the defenses we can raise on your behalf.